sent to our client. By predated, I mean it was dated 2 weeks before the postmark. So either the letter sat there for 2 weeks and they didn't mail it, or they predated it 2 weeks before they put it in the mail. Why would they do this? Why would a debt collector predate a letter? Well, primarily it's to get around 15 U.S.C. 1692G, which is part of the FDCPA. And this portion of the statute requires that the debt collector, within their first communication, written communication, they give you 30 days to demand validation of the debt. And if you do so, if you demand validation within the first 30 days of getting that letter, they have to stop their debt collection and they have to go validate the debt. Once they do that, they can start collecting again. So why would they do this? Well, if they shorten the time you have to respond to request this validation, they get to keep collecting when maybe they're not supposed to. That's how they get paid, right? Many debt collectors may only have the account for 90 days. So giving you 30 days to do this and then possibly having to actually validate the debt, pretty much makes it impossible for them to do anything before the account's taken back by the creditor or the junk debt buyer who owns it. Also, there may have been a phone call from the debt collector prior to any written communication. That phone call requires that they send a letter to you within 5 days with certain information so they can put you on notice of the debt and specifics of that debt. If they blew that day, if they called you on March 1st and then realized March 15th they hadn't sent the letter, well, the easy thing to do is just predate that letter so they can at least appear to comply with the FDCPA. So the question really is this a violation? And I would say 100% it's a violation. And 10 years ago, I would have sued for this every day of the week, twice on Sunday. But things have changed a little bit. And so this is probably a good point to pause and talk about standing, or as I call it, actual damages. The Supreme Court, and by virtue of that, most of the federal courts use damages as a way to avoid hearing cases they don't want to hear. They will say you don't have standing. If you don't have standing, we don't have to hear it. Even if there is a violation of the law, we're just not going to hear it. Typically, they do this for political reasons. This has been an issue since John Marshall created this construct when he was the Chief Justice of the Supreme Court back in 18-something. The reality is that this really only applies to consumer cases or cases that the courts just don't want to hear. If the judges do want to hear it, do want to hear the case, they're pretty adept at talking their way around this issue and finding out there's either harm or the potential for harm and getting it to a jury. The FDCPA and many consumer protection statutes have what we call statutory damages. But these aren't tied to actual damages or actual injury to the party. So the courts have said even if there's statutory damages, you still aren't harmed. And so we're not going to hear the case. And the statutory damages are there for the purpose of preventing the federal government from having to regulate these industries. They said we could have a bunch of regulators out there enforcing the laws on these debt collectors, or we could just give consumers $1,000, which in 1977, $1,000 was probably worth it. Give consumers the ability to sue these debt collectors, and if they're successful, then they get $1,000 plus their attorney's fees. Makes it worthwhile. They don't have to do any work. The industry gets regulated by consumers. It's a win-win for everybody. Well, at least the consumers in America, not maybe so much the debt collectors, but wasn't really designed to protect them since they were the problem. And it worked pretty well up until about 10 years ago, and our Supreme Court kind of brought back in they found reasons to get rid of these cases, and they've been working really hard to do that. So the last 10 years, it's taken a little bit of a hit, but there's still good cases there, and they still have to hear them sometimes. The question is, are there damages here? And maybe, did the consumer send a validation late that was ignored because of the false date on the Dunning letter? Did the consumer fail to demand validation because there just was very little time to do so, or was there no time to do so? In those cases, there could be some actual damages, and if the judge is going to believe that and put faith in that and not just ignore it because it's a consumer case, then you can still bring it in federal court, and really that's just going to depend on the judge, and we generally know which judges are going to respect the laws that Congress enacted. But if you got a judge or potentially have a judge that won't do that, what are your options? Well, state court's an option. Many times, not every time, because some state courts have a similar standing provision, which we can always argue there's standing and there's damages. The question is whether or not a judge is going to agree with that. And so if a judge doesn't agree with it, then it's you're relying on a judge to do the right thing. And sometimes they do, sometimes they don't. They're kind of human in that regard. So you potentially have a state court option. Interestingly enough, we've seen a lot of state court filings made, and then the debt collectors will remove it to federal court because there's a federal statute, which they can do, And then they'll claim there's no standing in federal court because there's no injury. But they're the morons that removed it. That's interesting. That's the word I'll use for today. It's interesting. But then it goes back to state court if they're successful. Pretty dumb, in my opinion. But that's their choice. The other option they have, or we have rather, is arbitration. If the underlying contract was subject to an arbitration provision, the junk debt buyer or the debt collector is probably subject to the same provision. And I have not seen where there is a similar standing requirement between AAA, which is the American Arbitration Association, or JAMS, which is the big arbitration companies that are usually contracted, or they're in the contract as being the arbitrators you have to use. I haven't seen where they've levied this standing requirement, and in fact, I don't think they would, because they get paid for hearing. They get paid for the amount of work they do, so they want to get to a hearing because they get paid more to go to a hearing, versus federal court or state court, where once you pay your filing fee, then they're kind of they can dismiss any time. They still get to keep their fee. The arbitrators, they get paid the more they do, so they want to go to a hearing, I think, and hear it out. So if you have a low dollar case where it may not really be any actual damages, arbitration, I think, not every consumer lawyer is going to agree with me, but I think arbitration could be a viable option. But if you have any questions about this or any other consumer law issue, happy to try to help. Cliff Carlson Law, give us a call.